intellectual property rights of research methodology. A man with a great vision and mission, an icon for hard work. He is our chairman, Dr. D. Peter J. Sudas. I welcome you, sir. I sincerely welcome our vice chairman, engineer P. Praveen J. Sudas. I welcome you, sir. I warmly and respectfully welcome our principal, Dr. A. Benham, who has been a pillar behind this workshop. I welcome you, sir. I heartily welcome our today's chief guest, Dr. Sheetal Chopra, Director, IPR Policy, Course Coordinator, IPTSE in Kapila, Ministry of Education. I welcome you, madam. I extended my welcome to our Vice Principal, Dr. G. Gaston Castro, who is the backbone of this 3 days workshop. I feel happy to welcome our Research Dean, Dr. J. Sunil. He is one of kind support for the 3 days workshop. I welcome you, sir. My deep welcome to the coordinator for this workshop, Mrs. Anusha Vincent and Mrs. P. Renuka, and all the teaching and non-teaching staffs of Annai Velangani College of Engineering. Without your support, it won't be a good, and I welcome you all. Last but not least, I welcome all the participants for the 3 days workshop. Once again, I welcome everyone to the Research Methodology Workshop. Thank you.
Thank you. Okay. Thank you, sir. Now I request our respected principal, Dr. Benham, to give the presidential address. Please, sir.
Honorable Chairman, Dr. D. Peter Jesdas, Honorable Vice Chairman, Engineer P. Praveen Jesdas, respected Vice Principal, Dr. Gaston Castro, distinguished Speaker, Dr. Sheetal Chopra, Director, IPR Policy, Ericsson India, Dean, Dr. Sunil, Director, Engineer David Philip Daniel, Manager, Mr. Manihandan, HODs of various departments, coordinator for this workshop, staff members, participants from various parts of our country. A warm good afternoon to all. I am delighted to see that the internal quality assurance cell of our college is organizing this 3 days virtual workshop in intellectual property rights within very short duration of time. The main goal of this workshop is to provide an overview about IPR, entrepreneurship, and procedures to convert your innovative ideas into intellectual property rights. Of course, the various funding sources for all these. My heartfelt thanks to our resource persons for providing their valuable time and sharing their knowledge with us in spite of their busy schedule. Also, I congratulate all the participants. I could see your passion towards this workshop. I hope this workshop will definitely provide you a good platform. I wish this workshop a grand success. Thank you, one and all.
Thank you, sir. Thank you for your valuable words. Now I request Mrs. Anusha Vincent, Assistant Professor, Department of Electronics and Communication Engineering, to introduce the resource person of today's section. Please, ma'am.
Good evening, everyone. I extend a warm welcome to all those who are present here. I find immense pleasure in introducing our honorable chief guest, Dr. Sheetal Chopra, who is an industry professional with 2 decades of experience in public policy and government affairs. She is a registered Indian patent agent and an author of the book on patent agent examination published by Notion Press. She has an extensive experience in international trade, research and advocacy, policy development at domestic and international level. Dr. Chopra is a visiting faculty and trainer at various educational institutions, government forums such as All India Radio, National Institute of Intellectual Property Management, IIT, NLSIU, etc. She has been recently awarded with prestigious award by World IP Forum on Power Women in IP. She is a course coordinator for IPTSE, which is an intellectual property talent search examination, one of its kind IP Olympiad. She has been instrumental in developing customized ebook for students of IP Olympiad that is suitable across disciplines. With that being said, let me now call upon Mr. Vansh Gupta, Project Associate from IPTSE Academy, to take over the session. So please.
Once you seem to be on mute. Looks like some technical issue. Or maybe you can call upon Ria if she's around.
Yeah, she can unmute herself and please proceed, ma'am.
Okay, maybe there seems to be some issue at their end. If you want, maybe we can start with the presentation.
Okay, ma'am, if that is comfortable, you can carry on with your presentation, ma'am.
Yeah, sure. I think that is okay. Just let me know. I'm trying to share my slides. Let me know if you are able to see it. Can you see that?
Yeah, it's
Yes.
visible.
Wonderful. Thank you so much. I am very happy to be in the midst of all of you. And thank you so much to your college, an esteemed college, to Principal Saab, Vice Chairman, faculty, students, other guests, and team at IPTSE for inviting me today. And it is overwhelming to note that your institute is organizing this awareness campaign on IP for the first time. And I fully believe it's not the first time, it's just the beginning for several more conferences and interactions to come. I'm more than happy to support your institution in whichever manner we can. So I have been asked to deliver a presentation today, which had to be more inclusive with regard to the overall environment of IP and what are the different kinds of intellectual property. Let me just do a quick hygiene check. Is my voice audible? Am I loud and clear?
Yes, ma'am.
Yeah, it's audible, ma'am.
Perfectly audible. Perfectly audible.
All right. Thank you so much. So what I was just saying is that I was being told to come and present about all about IP, including patents, copyrights, trademark, trade secrets, industrial design. But then later I thought that it may not be right because 45 minutes is not something that we can cover all about IP. And I don't want to push a lot of information on you guys because it's for the first time that you are here to learn something about IP. So we'll try to make it more interesting. Let me also convey that today's presentation has been compiled by one of the research scholars. I haven't made it, I'm just presenting it by Saundarya. And she's the one who won, she's one of the rank holders for third edition of the IP Olympiad. And I'm so happy that students who are now winning are actually supporting IPTSE Academy in developing certain very nice content on intellectual property. Not only they are learning, but they are also making others learn about it. So it's a moment of great pride for me to be presenting her slides. And I'll just give my input on these slides regarding my experience. So in today's slides, it is more focused towards teachers and students, because that's what I believe that all of you who are here belong to these two categories. Just a small disclaimer that I definitely want to say that anything that I say today belongs to author itself, meaning my own views. It's not connected, shouldn't be connected to the organization for whom and where I work. Anything that I say today shouldn't be construed as a legal advice. It's purely and purely for academic discussions. About myself has already been told to all of you. Not only I wear a corporate hat, but I also wear academic hat. And that is where, teacher in me speaks most of the time. And therefore, I love wearing that hat, which is more academic in nature. So why do we need an IP awareness at the first place? I'm sure that when you as a university decided to do something on IP, something must have occurred to your mind as to why is it that you want to do this? Why do you want to make your teachers and students learn about intellectual property. I think सबसे बड़ा benefit and one of the very interesting facts is that most of the innovations and creative content is actually coming from Indian academicians when it comes to our nation. And I can safely say, of course, we can find out the right resource or the source for this information, but it is said that 90% or most of the innovations are actually coming from academia, which is then later picked up by industry, and then it is then further brought to the market by certain other studies and by developing it further. So as academicians, you all are actually working and doing great work, and therefore it becomes extremely important for you to understand what these innovations and creativity could be, how to protect it, how to monetize it, because why just create for others? Why not for yourself and for the nation building? And therefore, I think it's a very apt time that you're doing this awareness campaign. And at IPTSC Academy, which is that administers intellectual property talent search examination, it identifies talent, from our country as to who all are IP literate or who are the ones who have got a better understanding of IP. And this academy then nurtures them to the next level. And this is where people learn more about IP, they take tests and get certified. So to, like I said, there are several types of IPs. Patents hota hai, copyright, trademark, design, geographical indications, plant varieties, Biodiversity Act, and there are several more, like trade secrets as well, which is not written over here. But for today's session, we are just going to cover the first two bullets, which is about patents and copyright. And I will start with copyrights. I was being told by Dr. Castro that today, those who have come for learning more about IP are also from design institution. These are the people who are most creative in nature. Not only them, but also engineering students, right? Because you are the one who are coming up with the coding, you are coming up with the machines, with new technology. So two types of IP are extremely important for you. I will try to give you some of the case studies so that you can relate with different types of these two types of IP better in the subsequent slides. But try to understand a basic difference between copyright and patent is that copyright protects literary work, dramatic work, musical, artistic, cinematograph, film, sound recording. It also includes computer programs. So copyright is more related to artistic content, creative content. And what is patent for? Patent is a legal right that is given for the technological innovations. It is given to the invention which solves certain problem in the market. Let's say there is a problem of COVID and people are inventing vaccines. So vaccine production or the modes of creating the vaccine, the process and the final vaccine will go into a patent. But if you open up, let's say any injection, jab aap chemist shop pe jaate ho, and you try to buy some medicine and you open up the medicine, you find those pamphlets which states, okay, what is the safety and efficacy of the drug, when to take, how to take, all that written material, which is a literary work, actually goes into a copyright. So therefore, one particular invention can actually have multiple IP rights. It can go into some parts of it can be protected under copyright. Like I just gave you the information about the example about pharmaceutical industry, how patent and copyright, you can actually protect your invention. Similarly, if there is a packaging insert, which an engineer has developed so that, sunlight does not destroy the medicine, that packaging insert and the way how it is developed to safeguard that drug goes into a design protection. So there are different IP protection, but let's confine our today's lecture or address to only copyright and patent. Okay, so what is copyright? As I just mentioned to you, it is more related to music or more related to, let's say you have drawn something on a piece of paper, your artistic designs or anything related to, let's say, production of films. These all gets covered, including the copyright, including the software code in the copyright protection. But you may ask, Mera isse kya lena dena hai? Where is my work, relevant when it comes to copyright? So as students and teachers, given that it's a digital economy and today everybody is online, like we are online right now, whatever I am presenting is the content that belongs to me. Similarly, teachers who teach the students online by developing certain very interactive course content belongs to you. And that's where your copyright begins. It kicks in. The moment you create certain, let's say, question papers, or you compile certain data, you do some analysis, you develop some reports, assignments, essays, stories that you write, your students do some mock, some theoretical presentation. All of those work gives you a copyright protection. So that's about the copyright and the works that can be protected when it comes to students and teachers. And what is excluded? There are certain exclusions to copyright, meaning agar kuch discovery hai, aapne kuch discover kiya which already is in the nature and you've just discovered it, you cannot protect it under copyright. You cannot protect ideas, like aapne ye ek idea aaya aapke dimag mein ki there is a boy and a girl and a villain, and both of them likes a girl, so it's a love story triangle. This is an idea, but that idea will not offer you a copyright protection, because if it did, then you wouldn't have seen so many Bollywood movies, most of which circle around this triangle story. So idea is not protected, it is only the expression of that idea. For example, the plot, or the way you express. For example, you may have, as a teacher or a student, you may be writing a thesis on a particular topic. Both of them will have separate copyright protection, because your the facts, how you present, how you make it more analytical in nature, how you present it in a way that it becomes more interesting for people to digest it. So all that, it's only when you express it, if only you fixate it into a tangible thing, like you write it down in a particular manner, that's when you get a copyright, but the ideas won't get a copyright protection. May I just request others to go on mute, just for the benefit of everyone, so that there is no background noise. Ria or Vansh, whoever is present, can you please keep a track of any chats or that may come which might require our attention?
Yes, yes, sure.
Sure. Why should we know about copyright protection as teachers and students? It is extremely important because you are all engaged at all times now, especially in the pandemic time. During COVID times, like I said, you're creating something which is more interesting. देखो क्या होगा ना, online आप, even if you say बच्चों आप अपना video on करो, they might go off to sleep if it is so boring. So teachers have to be very creative now to keep the attention of the students. And therefore, I think the research scholar who developed this PPT for me made it very classy and very colorful. You see orange and blue and whatnot. Every color is there. So similarly, any content that you as teachers create, or any interesting or anything which is interesting that is created by students, offers can give you a copyright protection if it falls within the legal norms. Okay. So what is copyright infringement and a plagiarism? I think as academicians, you would have heard a lot about plagiarism, that one professor or that student or that teacher or that child, he copied someone's content. And you must also be hearing a lot of court cases where there is an issue about copyright infringement. For example, that person stole other person's music, or that movie looks so similar to the movie developed by some other producer, or this thesis of a research scholar was copied by XYZ student of another college. So you must be hearing these two words every day and night. And let me just quote a very quick difference between the two. Plagiarism is more of a simple copying. Here, intention may not be to commercialize or to earn money. Intention may only be to use someone else's work and pass it as yours. And this is primarily seen, when students are given some projects at home, they immediately open up the Google and they Google it. They try to find out some research papers, copy paste and give it to the teachers. That's where plagiarism is. It has nothing to do with court case or something. But when it becomes a court matter, more even before that, if the intention has been to commercialize the work by using someone else's work, reproduce it or distribute the copies of the work. For example, you have taken something from me, let's say a book, ebook from me for rupees 400, let's say, and then it was only for you to read, but you actually put it on the server of your college and started distributing to all others. That's where copyright infringement comes in, because it decreases the value of someone else's work, because people won't be happy to buy that work anymore because it's somewhere available on the college website or college server. So this is the key difference between plagiarism and copyright infringement, which you all must be aware of when you start to venture into the idea of IP. In fact, there has been one very interesting case, a DU photocopying case, if you all heard about it. So there was a judge, and Oxford University Press and Association of Publishers of India, they sued Delhi University because most of the students were found copying the course book. So suppose कीजिए आपको 7 books पढ़नी थी, and out of those 7 books, you just picked up some chapters from the book and prepared a course pack. You went to a copyright bhaiya and said, please get me the photocopies of these. So this was the case which was filed. And the judge said that this is absolutely okay because it falls under fair use. Because anything that is done only primarily for research or private study, or for criticism or review, or for academic discussions, let's say, for reporting of some events, or maybe let's say an amateur club or a society, if you're performing something, let's say within your college premises, then such work, use of work, falls under the fair use. Fair use meaning where it is fair enough for you to use, because you are not going to commercialize it in any which way that reduces the actual real value of that IP. But the question comes under the ambit of fair use, what all can you do? Meaning, as a teacher, you can always say, oh, I'm a teacher, I'm a student, I can copy anybody's work, I can copy anything from someone else's research paper, put it in mine, in my work. So it shouldn't be misunderstood that fair use is just an it is just an exemption, but it is not a norm. Exemption means it is only in those limited instances or time when you can actually use it, but not otherwise. And let's just look at when is it fair use. So whenever you as a teacher or a student want to know that I'm copying someone's work, would it fall under fair use or not? Can everyone just please go on mute? So you have to see what is the purpose of the work. Whether the purpose of the work is commercial, then yes, it does not fall under fair use. You have to also see what kind of work are you using. For what are you using it? For criticism, yes, you can use it. If you want to do a parody out of it, yes, you can use it under fair use, and you don't have to be really concerned about the copyright infringement. But if it is for just copying someone's work and passing it under your name, then certainly it doesn't give you that immunity of fair use. Amount of work also is very important as to how much of the work are you using. Are you using 90%? Or are you using less than 5%? Are you using less than 10%? Then also that's a very important criteria. I think best is to just paraphrase it and also give an attribution in the footnote or in the endnote. And also one has to see what is the effect of use of that work on the original. आप कुछ ऐसा तो नहीं कर रहे that it really undermines the value which is of the original work. Let us see some examples to understand it better. एक example लेते हैं. A student writes a poem which is about his life at his school, and while writing that poem, he picks up the lines of a very famous author. Now, when he is sued, let's say by that author in the court of law, he cannot say that I was a student or I am a student or a teacher, let's say, and I am allowed to use that author's book or the lines from that. No, it will amount to violating author's copyright. So just because you are a teacher or you are a student, you cannot take that excuse of fair use. Example 2, let's consider a teacher attends an online workshop, and for that college has paid for the teacher, let's say 1,000 rupees or 500 rupees. And for that payment, that teacher was provided some course material. Now, if she further starts to sell that course material, let's say at a particular cost, let's say 200, and she says that, okay, I have this now and I'm happy to sell it forward, then this is a copyright infringement. Now, there is use of this article without the permission. So you'll find in some books, right on the page 1, you'll find some warning that do not copy any work that is given in the book. Do not try to distribute even for, for any purpose. Then when you find these warnings, then it is good enough an indicator for you that you cannot use it just like that. And you need to seek the permission of the copyright owner. How to avoid copyright infringement claims? I think the best way is to give attributions. Always mention the source by writing the full name of the author and publisher, and also from where have you taken the content. I think you might be, it is very interesting to understand why are we even trying to understand this copyright perspective, because lately, due to all of us being pushed to digital economy or digital environment, I would say, not economy, but digital environment, there are growing cases globally, may not be in India as much as yet, but the jurisprudence is evolving. There are a lot of cases against students, against teachers, or against other professionals, because suddenly, there are whole new nuances that we were all not aware of just before. Let me just give you, instead of just going through the slide at this moment, one very interesting live instance comes to my mind, that when I was creating a YouTube video for my son, we used this 3-second clip, which was available on Creative Commons, and we downloaded and attached that clip along with his work. So 99% or 96% was his work, with 3% of only 3 seconds of content that belonged to other. It was just to make it more, more nicer and to give it a more color. And there was a notice which was given by the YouTube channel that, this content doesn't belong to you. And when this was given back to the YouTube that no, this whole content belonged to us, it is only that less than 3 seconds of someone's work which is being used. And there is enough attribution also given as to from where has that been taken, because there was a source mentioned. And that's where, it was then stated, okay, that's fine. So, this whole nuances of infringement, sudden notices that may come to you if you're more active on YouTube and you've created your own channel, or you're developing some course content which has a lot of content for students, you may fall prey of certain such instances. And therefore, we are all reading about this at this minute. What else that you should do is that minimum copy paste. Do not just copy paste for the heck of it to make the job easy. Try to paraphrase it, and whatever you want to copy paste, just the minimum amount. Now, there is no yardstick. Okay, Dr. Chopra, how much minimum do you recommend? Is it less than 3%, 5%, 10%, 40%? What is that minimum? So that minimum is not prescribed anywhere, but I think it is more related to your intent as well. But anything which is more than 10% is certainly not agreed to, is not accepted. But even if it is less than 10%, then give still enough attributions that should definitely go. Try to use the documents which are in public domain and not something which you may have just taken an access from your friend circle or from anywhere else. Try to also use most of the content which is of open access, where there are no copyright claims. Now, if there is an author who has expressly prohibited that you cannot use it, then certainly you must not. And then you try to identify who the copyright owner is, contact them and ask them for their permission, and also ascertain the use as to how much of the work will you be using, and you should be giving the attribution. Please feel free, Dr. Castro, to stop me anywhere where you think that more information is required or something that needs to be stated. So there is one.
Participants, please mute the audio.
Yeah, you can mute the audience.
Dear participants, kindly mute your audio. Thank you.
Yeah, I think someone from IPTSC Academy can also put everyone on mute. I think they've got.
I'll just put everyone on mute and I'll ask you to unmute if that's fine.
For me? Yes.
I will
Um,
be.
yeah. So
Yeah.
I will go ahead now. So there is one question in the chat box by Dr. Surya Bahadur, and he's asking, is there any percentage of fair use under IPR? It's a very interesting question. There is no percentage to even fair use. Fair use can, if you are actually, it falls under the ambit of fair use, you can use the complete work. If it is only for, let's say, those few things which are listed in the Copyright Act, that you are using that work for teaching purposes, it's not going to be for commercial use at all. It's for parody, it's for criticism, then there is no percentage at all. Percentage come when it comes the case of copyright infringement, as to how much work have you used when you were about to commercialize or when you were commercializing, or whether there has been the value that has been decreased as a result of any of your actions. So thank you, Dr. Surya Bahadur, for asking that question. I would encourage more and more people to put question, because I think the best way to learn about IP is by asking questions and by interacting. Otherwise, it will be just a monologue. I'll just read up the slides and go. All right. So, Ria, still people are on unmute. If you can just look at it once. So when you are the creator, meaning when teacher and the student is a creator, I think this is the most interesting piece, because there are a lot of internal ruckus between the college authorities sometimes, where student or a teacher comes up with something very interesting and student says, oh, it's my work. Teacher says it's my work, but college says, no, this work actually belongs to me. So there is a complication that usually comes, and I'm sure now that when you are guiding your students on IPR, they'll be bound to you'll be bound to see such or witness certain instances. So it's better to learn it now. And the answer mostly lies in the intellectual property policy of that particular university or that institute. I'm not sure whether your university still has an IP policy. If not, you must, and you must take help of IP experts. I'm sure that people at IPTSC Academy have expertise to help and assist your institution to develop one, but it is must to have one in order to address to these issues as to whether IP belongs to a teacher or a student or to a university. Just let us look at some internal contracts. There are three ways how you can look at the kinds of work. One is the internal contract. At the time of signing up the employment with the university, or at the time when students register for any course, then you must look at what you're signing up for. Maybe that agreement itself talks about whether anything that you do during the term of your recruitment, during the what all is the job description. Please go through what your job was. Was it just to teach? Was it also to develop course content, or was it to also innovate and create something? So what did it all include? If you have done something beyond what was not stated in your contract, then that intellectual property belongs to you. Then your college or university cannot take the ownership. But if it is other way around, that it was written in your job description that maybe, let's say, you'll develop a book, then even if you develop a book, it doesn't belong to you in terms of ownership. And we will try to find out the difference also. Let me try to give you a difference. There is a difference between ownership and the authorship. A teacher or a student can still remain to be an author or an inventor, but the ownership may still go to the university, which means university will have the right to sell that work, to find out the collaborations, to sell that work and earn royalty and maybe share it with the college student and the teachers. But the authorship and inventor will always remain with the creator. So that difference I wanted to definitely tell you, that even if you don't get the ownership to sell that work to anybody else, or to do whatever you want, but you still remain to be the author or the inventor of that work. Second is exam related. Most of the time there are paper setters who develop some certain question papers, and they give it to Board of Education. Does it mean that the Board of Education or the government body becomes the owner of that question paper which was set by certain persons? Then there is a very important case, Agarwal Publishing and Board of Higher Secondary, which made it very clear that no, government does not become automatic owner. The ownership and the authorship vests with the paper setter. So you can claim as a teacher that this question paper was set by me. The way I had set is innovative and creative, and people cannot just use it left and right without asking me. Similarly, students who are the primary owners of the answers. So all of you as students, when you write answers, I'm sure that you all don't write exact same. It all comes out of your own experience, your own learning, and the way you write the answer, that expression belongs to you. So you are the owner of that answer also. It cannot happen that, you know, some book publisher takes the answers from your answer sheet and publish a book. They have to come back and ask your permission. So if there are any students today hearing this who are very creative, the way they write answers are very interesting, you can actually interact with a lot of publisher and say that, okay, if you're developing some book related to a particular thing, I have answers, I can write them better for students to understand. So there is a monetization activity available for you already. For any other types of work which do not become part of the contract or anything which is in the written agreement or otherwise, then the ownership belongs to that particular teacher or a student. Let us just understand them by way of some example. Let me just be cautious of the time. Okay, we still have time. So there is an example one, a teacher who is employed. She has a contract with the university, and where she was assigned to write textbooks on botany, or let's say on any subject. The copyright will not lie with the school, as the book was not her duty. If the contract did not say that she has to write books and she ends up writing books, then that work belongs to her only and not the university at all, because it was not cited as a part of her contract. Let us look at the second example, where let's say a student, I'm sure that many of the students attending the conference today, I'm sure many of you will be creative enough to develop certain soundtracks, and I'm sure that you must be having some music professor either at home or in the college or somewhere else. Let's say if you write a poem and the professor, he develops a musical portfolio using your poem, and that is utilized in the college during, let's say, an award show or any fest, then the copyright actually belongs to both student and the professor, because both of them got together to come up with a final piece of work which can be enjoyed by public at large. Also note that there are two types of rights that every author gets, every teacher and a student gets, which is a moral right and an economic right. Economic right completely depends, as to what are the platforms, how you are selling your work, you're licensing your work, you're monetizing your work. But moral rights definitely give you the right that even if you have assigned your work to, let's say, university or anybody else, then nobody can mutilate or destroy your work without your permission. Nobody can make changes to it, because that's the moral right that you own. And similarly, if university owns certain work and it assigns it to some industry, then as per the moral rights, the work cannot be destroyed, mutilated, changed without the permission. And moral rights oftentimes also give the economic rights for somebody to earn money out of it. Okay, when you are an author and an owner, okay, thank you so much. So when you are an author or an owner, it has been established that the teacher or a student is an author as well as the owner, and they can protect their work. And let's say if it is enough clear that you have the ownership rights and the authorship rights both, then you must publish your work once it is done, so that people can take note of your work. You should also mark it with the sign C, as you can see on the slide as well. You should mark it with C, so that people get to know that it is a work which is under the copyright. There are other legal options that one can explore. You could actually register, although protecting your IP, under copyright is not mandatory because India is member of Berne Convention. The day you create, you get your copyright, but it is always good to still register. And it's from the perspective of policy as well, because government and every one of us as consumers get to know who is creating, how much is being created from India. But also when, God forbid, somebody has to go to the court and claim for the right that someone has used it, then the judge will definitely ask you for the prima facie ownership. That did you register? So that registration helps at that time. Licensing is where you can ask for payments or royalty if you are licensing it to somebody else. So license are given for the book. They are also given for a lot of work, creative content, assignments that you create. Many publishers want to use some research piece of some work of research that you may have come up with. Keep in mind, always read the employment contract. It's not only for the schools, teachers, or college teachers or students, but also for the universities to develop a very robust employment contract. Because given the time that now we are in, government is pushing hard that everyone should think innovative and creative. It's important that you develop your own policy and also the contracts, which takes care of important pieces. Encourage your institute to draft a very clear and concise IP policy so that you don't fall flat of any such legal challenges that may come. Keep proof of creation at all times. Put it in the lab notebooks, put it in your diary so that you can show at a later stage to authorities that you are the ones who created it first. Display the signs of copyright ownership, put that C mark, and also seek professional advice when you need it. So as I already said, ideas are not protected, but only expression. If you have come up with idea, other persons may also have a similar idea, but all depends upon who is expressing in what manner. Keep records before you share. So if you have any idea and you want to tell it to somebody else, do not just go ahead and start sharing because it can be copied. Put it in the lab notebooks, put it in your workbooks, books, and other important places where you can later on prove your ownership. Online teaching, we all know that we are all doing online teaching. I should have myself put C mark, but I did not because in my work that I'm presenting today is free for use, and you may, as university, you may like to use it. Try to always put watermark whenever teachers and students are presenting online. Put watermark, which gives your name, which also states whether there is an access restriction. Because कई बार ऐसा होता है कि teachers they present it in the school, in the college, and later on they find that the same piece of work is in the hands of some other students of some other college. So put that access restrictions. Also have a copyright policy. Inform people where to look for the authorship, who to ask, and provide all information that is necessary. For example, date and time of publication. In fact, like when I was presenting, there is a date that you may see somewhere, which says that when did you present the work? Because let's say if somebody is like clicking the photo of this particular slide, which unlike me, maybe some experts do not want to share, then with that click, even that date, time, and the place will also get recorded. So then if later on that thing is being found at some other place, you can actually find, even it's a way to communicate to the infringers that do not infringe and this is not for everyone to use. Also try to put disclaimers besides that C symbol, but provide for a warning and always stay alert whether your work is being copied or not. Also stay alert that you are not copying anybody else's work without due permission. There is a copyright law in India, very robust. In fact, it's a great pride to say that the copyright law of India is one of the best in the world, because almost everything that should be there to protect and safeguard the piece of work and for the benefit of public at large is there. But be careful and be informed that if someone is found infringing your copyright, what all you can ask for a court in relief. You can ask for the damages. You can also ask for compensation in the amount of profits. You can also ask, actually copyright violation is not only a civil offense, it is also a criminal offense. So considering the gravitas or gravity of the infringement, you can actually The infringer may be imposed a fine of 2 lakh rupees, and he may also be, or he or she may also be imprisoned from between 6 to 3 years. So it completely depends upon the level of infringement. Also, let's consider that somebody has not commercialized the work, but has just utilized your work. In that case also, one cannot claim that I never commercialized, I have not earned any money. That person will still have to pay a fine of close to 50,000 rupees and maybe an imprisonment of 6 months. And there is a section already written here. So that brings us to the end of copyright, and we are sharp at 4:45. I will try to cover patent section in, let's say, 10 minutes, and we'll give it to Vansh for his presentation. But at this stage, if there is anybody who wants to ask any questions related to copyright, please do ask now. Vansh, Riya, if you find any question in the chat box, you can tell me right away. So there is one that I can see by.
There is one question
Yeah.
from V. Patammal.
Hmm.
So he's saying that as an academician, he's involved in many projects in tune with industry while commercializing the same as a contributor. Is he entitled for royalty? Sometimes UGC funds such projects along. Does that entail he shares the IP with them too?
Right. It's a beautiful question, I would say. It's because it is really linked to the on-ground issue. Let me try and attempt to address. So you are asking that there are many projects in which you are involved, for which there is already a UGC funding given. There is some government funding, and later on, you are also trying to work in sync with the industry so that it could be taken to the market. And whether at the time of commercialization, would you be considered as a contributor and be able to receive royalty? Exactly. It again, the answer lies in one of the slides. If you heard, I said that answer lies in the contract. What have you signed a contract for with the university while taking up that assignment under UGC projects? If that says that yes, there is a particular project that has particular nuances and these are the inventions that one has to make, you certainly will be considered as a contributor, as an inventor. As an inventor, your name in the patent application should certainly go. And if the contract says that because it's a UGC funded project, it has come from the university, you're using university sources, then certainly yes, your university becomes the owner. Now, if university becomes the owner, it is not important that only university gains in form of royalty. There is the IPR policy that should ideally be there for the university, which should state that what percentage will go to the inventor and what percentage would university keep. And it keeps changing. Sometimes it is 60-40, that 60% is retained by university, depending upon how much of the course, how much of the material of the labs and other things that you have utilized. And sometimes it is the reverse. It is 60% or 70% of major portion that goes to the inventor, to professors such as yourself, and lesser amount is kept with the university. And some small amount, let's say 5% to 10%, is given as the facilitation charge for the university, because university has helped you in filing for patent application, for getting it granted, and for getting the industry. So those facilitation fees kept. So it completely depends. I really encourage that you get in touch with experts at the IPTS Academy, get more learning about how to develop that IPR policy so that such issues can be sorted. But now, to cut short, I think it is definitely given that you as an inventor will also earn a royalty, but yes, you have to check your contract for the same. Are there any other questions? If I hope Ria have been able to give answer to Mr. V. Pattamal, if that is okay, and else you can also give me another question that
We
you may
have
have.
more questions.
Yeah.
Gayatri is asking that when a design is registered by both university and the student, what percentage of royalty each of them gets? And how much at maximum can the university get?
Yeah. So again, the answer lies in the IPR policy of your university. Every university has got completely different. Sometimes it could be in sync with each other, but most of the time that university decides all of these as a part of the contract and also as a part of the IPR policy. So for a design, let's say when a design is registered, that university is the owner and the student is the inventor or the creator. And if it is then commercialized, one, you have to first see who is commercializing. Universities usually don't commercialize. They actually give it to the industry to further advance it and put it to the market. Find out how much is the university paying to the industry paying to the university, and then basis the IPR policy you have to identify. And it also depends how much is the effort put by the student, how much is the effort put by the teacher to guide that student. So there are several factors which are seen in order to finally find out what royalty amount should be. But sometimes universities are very clear that we don't want to keep major portion of royalty because काम तो student ने किया है or teacher ने किया है. So they give maximum royalty to the teacher or a student. And sometimes it is the reverse. It is university who keeps, because there is a lot of facilitation that the university has done in scouting for the right industry, in getting the project from the government, in getting industry funding. So it completely depends. Anything else? I hope.
One last question.
Yeah, go ahead.
To edit the articles published in a college magazine, from whom do we have to get the permission?
To edit the articles published in the college magazine, but in what capacity are you editing those? Are you a part of the editorial committee? You are then automatically given the permission to do those jobs because it's a part of a contract. But if you're an outsider, then usually college magazines have the contact details provided to edit those. But simple editing won't help because I'm sure that there is an intention for you to have edited those. Maybe you want to republish or do what. I think I'll need a little bit more detail to understand your question and to respond it. But the permission will have to be taken from the owner or the author of those articles. Because most of the times what happens is that the one who writes the articles, the authorship rests with the writer, but again, the ownership rests with the publisher, that is the university. So you have to seek permission from both in that case. Anything else, Ria, at this stage, or do you want me to go ahead with the presentation?
I think we can go ahead with the presentation. We do not have any more questions.
All right. Then we have just 10 minutes left. I'll quickly try to pick your brains on the patent side of it. It is as interesting as copyright is, but patent becomes a little bit more complex because this is where we talk about inventions, technology, technical advance, the problem in the art, what market is facing a problem with, what solutions does an inventor have. But getting a patent is certainly not as easy as it is for the copyright.
Here, I think you have done a pretty good job as others, like many of your batchmates have done that. So you have compiled all your learnings, whatever you have learned throughout the course, and you have tried to put it together in terms of solving the problem areas in your product. All right, so that is something which is very good. Now here I want to see some more ideations. This is a very good idea, no doubt. This is a very good idea. It's like a scissor. I think there is some mistake with this drawing because it's looking like these two are separate, entities. It should go cross like this.
Is it
If
the
it
part
goes
of
cross
this
like this,
series,
so
or
how
are we
is it
having
going to be drawn?
some other lecture going on?
It should be
Then
plain.
maybe you want to
But
mute.
I think apart from this is a good idea.
Thank you so much. Yeah, it happens, when you have multiple discussions going on. So patent is a right which is granted, just like, we get a copyright granted by a federal authority of government. Similarly, patent is granted for the innovation, for the technology, for the new and inventive solutions. And there are few requirements. It has to be new. It has to have an inventive step. And it should have an industrial application, meaning anything that you create must be able to be scalable in the industry. People should be able to reduce it to practice. It should be able to solve some technical issue. And that's where you get a patent if it is new and it is not similar to the work that actually belongs to other. There are several benefits of getting a patent because then you become the exclusive owner of it for 20 years. You can actually earn royalty by licensing it out, by selling off your IP parts or in whole. And you can actually, it's like any other property. जैसे आपका घर होता है और आप घर में जो कर सकते हो, you can lease your property, you can give it on rent, you can sell your property, you can do a modification to it, further evolve it. All that you can do with a physical property, similar is the patent as a property that you can consider to be able to also earn monetary value out of it. There are several things that cannot be patented. For example, discoveries. If apple falls on the ground, it is because there is a gravitational force and it is a discovery. It's not an invention. It's something that nature does. You cannot file a patent for it. Similarly, any method that is related to agriculture or horticulture, you cannot patent. Anything which is medical or surgical or curative, even that cannot be patented. And in fact, there is a huge list of inventions which are, which cannot be patented as a result. And for example, a method of conducting a surgery, like how do you conduct a surgery or how you treat patients, these cannot be patented. Otherwise, every doctor will be stopped from curing you. And one doctor will always have to seek permission from the other doctor if one is to prescribe medicine. So therefore, the method of conducting surgery is not given patent. Mathematical formulas like 2 + 2 makes 4, or anything which is more mathematical, Pythagoras theorem, these are the things which cannot be patented. Similarly, anything which is already existing in nature, suppose there is a microorganism which any of us never saw, but maybe you discovered it, you cannot patent unless you make changes in the genetic makeup of the microorganism by putting your human intervention. The machines which are against public order, suppose koi ye bolta hai ki okay, I have invented something which can make stealing more easy or burglary more easy. I have found out, I have made an invention or a kind of an instrument that can kill somebody, easily without a noise. So these are the things which are against public morality or order and cannot be patented. Similarly, method of playing games cannot be patented, or anything which is our traditional knowledge, like use of turmeric or neem. It is already known in nature, right? It's a part of a traditional knowledge of the country. These cannot be patented. There is a very big process for patenting your work in India. It may take between 4 to 5 years, sometimes even more, sometimes lesser as well, depending upon how beautifully have you developed your IP, how beautifully have you developed your claims, what has been the quality of your patent application, and how quickly are you resolving the queries that your examiner is asking. So all that will decide the process of patenting, but there is a set process that you can at your later stage can look at it. Ownership of patent, again, like we did in the copyright, completely depends on the IPR policy of the university. It also depends on the contracts that you sign, so be careful of all of those. For teachers and professors who are employed with the education institute, usually it is the professor who owns the IP, not owns the IP. Ownership actually goes with the university mostly. If it is done during the time when you were to lecture or when you were in the college premises, how much time you have used the labs and other facilities of the university. So how much has been the direct instruction to a student by a teacher, or what has been the scope of your work, did you sign for, all that will decide your ownership. And also for students is the similar, whether it's an independent research, whether you've done it at your home, whether and how much has been the intervention of your teacher in developing that work, whether that work was developed under the university funding or did you get some funding outside of the scope. So all this will decide, and it's quite comprehensive, I would say. If we get into studying each and every part of it, then we might have to look into the policy and then look at each and every provision. But this is what generally is. Mostly it goes to the university, the ownership. student and teachers own the inventorship. And later on, whenever there is a royalty being paid out, then 60-40 usually the ratio, but also your IPR policy of the university will decide what royalty should go, if at all it should go, or it should not go at all. So it will all completely depend on what you have signed for and what your policy calls out. There are certain industry funded projects. Most of the times, like one of the persons just asked a question a few minutes ago, capstone projects are also given where students are asked to go and work with different departments. Like somebody will be pushed towards psychology department. Somebody will have to go and work with the engineering department. Some students will have to go to a management department. So while they are working on a capstone project where multi-party people are required to develop a particular product, then in that case, that student and a teacher from that department becomes the owner. So finally, when the patent application is drawn out, which has components and pieces from each of these departments, then the inventorship will be seen from each of these sections. And then finally, the product will be developed and patent application will go. So there could be a three-way agreement as well between the student, professor, the university, and the industry. So that's how you have to look at the nuances when you start with the project, in the midterm, and then at the later stage. There is a licensing available. That's one of the means, not the only means, but one of the means to earn royalty. How you want to license it, let's say to an industry or to somebody outside, or you want to sell it even. So those licensing terms will help. There are usually incubation cells that universities have. If you don't have, do please fall back on the experts, and they can help you in developing an incubation cell. And these incubation cells work with entrepreneurship cells and work with very close tandem with the Indian government and help in facilitating that licensing. And there are certain government departments who are doing excellent job in doing it, in helping, supporting universities and students and teachers in connecting with the buyers. And you must take the professional advice. There are certain tips for inventors in universities. Just like I said in the copyright section, always keep record of your work, detail it out. Always take credit when the work is being done by you. Shout out and let your teachers, professors, and universities should also in return give a scope of expectations to back, so that there has to be a two-way communication. Always read your university's IP policy, negotiate the terms of any project. Like someone asked, how much percentage will come to me? How much will go to the university? How much should industry pay? All that should be decided. All that should be discussed with the advisory team. Usually universities retain certain experts, and whenever required, those experts are utilized, their services are utilized, their time is utilized to develop some of those understanding on whatever we just discussed. And always do a prior art search. Don't come up with something which has been invented by others. It will be super waste of time. And there are a lot of prior art searches available. Ask for a legal help, ask for experts to get the nuances known. There is a difference between patent and a publication. I think this is the last slide that I would like to make. I know it's sharp 5:03. I'm 3 minutes ahead because we picked up certain questions in between. But whether you want to do a research or paper, publication, or a patent, I wouldn't compare between the two. Both are important, right? But the only one thing that you must definitely understand, that if you have published the paper before filing for a patent application, and there is a lapse of 1 year of a period, then you lose the right to completely have patent at any point in time. So forget about commercializing, forget about seeking royalty or anything else. If at all you want royalty, if at all you want IP to be commercialized, go for a patent and then a research paper. But sometimes as a strategy, you just want to see whether you want simply research paper, because maybe the invention that you come up with is very small scale. You don't want to invest a lot of time and energy and money in getting a patent. Sometimes your idea may be just normal, but with a very low commercial value. Then also you don't need a patent. But you certainly need a patent when your inventors have the opportunity to sell and license at a later stage. When there is a public disclosure, when you want to license it out, when there is a lot of research that has gone into it, then patent becomes must. So that's where I will leave all of you with the thoughts on the introduction to copyright and trademark, and over to the college authorities to now pick it up from here. Thank you. Okay, I would want to ask Vansh to quickly go through his presentation and then we ask the professors to pick it up. Vansh, go ahead.
Hello, am I audible now? Yeah. So good evening, everyone. This is Vansh Gupta, a project associate from IPTSC Academy, and today we are going to talk about IPTSC Academy and the intellectual property talent search examination that takes place across the country annually and aims to spread awareness about IP and its components. So IPTSC Academy has been awarded by World Intellectual Property Forum, and it is also signed by Sri Suresh Prabhu. So IPTSC Academy aims at spreading the intellectual property awareness among the students from different levels, from colleges and schools, and also the working professionals. And it also helps the education institutes to improve their NIRF, NBA, NAC, and ARIA rankings and accreditations. So, intellectual property talent search examination is an online proctored exam organized by IPTSC Academy on an annual basis across the country to provide information about intellectual property to all the fields of students. So, intellectual property talent search examination was launched in July 2018, and it's first and one of its kind of IP Olympiad on intellectual property rights in India. And it has been supported by various organizations like ASSOCHAM, Creative First, and several government bodies like Ministry of Information and Communication Technology, iHub Gujarat, etc. The exams customized for school and university students on the basis of their streams, including law, engineering, architecture, research, sciences and technology, etc. So let's talk about the eligibility of the exam. All the school students from the classes 9 to 12 are eligible to give the exam. Also, the university students from design and architecture, engineering and tech, hotel management, hospitality industry, law students with IB specialization, mass communication, and multimedia are allowed to give the exam. We also include faculties or working professionals or startups from the 4th edition of IPTSC or Intellectual Property Talent Search Examination. So here are the guidelines for the examination. The duration of 60 minutes is provided to the school students to attempt 60 questions and 45 minutes to the school students. Also 45 minutes for teachers and working professionals and startups. There is no negative marking in the exam, and to qualify, the candidate must score 40% or above of the following questions. And for the regional rank holders, we need at least 500 registrations from each region to declare them. And the process of examination consists of 4 following simple steps. First is the registration, that students are provided a portal to register for the examination, and the registration for the 4th edition would be live from the month of August. And the IPTSC Academy also provides students with the informative course material designed by our course providers, and also some smart links through which you can access videos and also refer to the IPTSC YouTube channel for knowledge about IP. Also, we conduct a mock test before the final examination so that the students get an idea how the exam is going to be. And it would be live in the month of November once you have registered for the exam. And the final exam would take place after a few days of the mock exam in the month of December. So the criteria of the selection for the winner is the duration of time spent on the examination, the duration of time spent on each question, the number of questions attempted on the basis of difficulty, and the same is for the national level winners. So benefits and awards that you get from giving the Intellectual Property Talent Search Examination are that we have exclusive cash prizes for all the winners and internship opportunities at various companies. Also, certification and trophies from IPTC team is provided to the national winners. Also, you can learn and earn with the various programs run by the IPTC Academy. And you also get a great knowledge about intellectual property by the course provided by the Academy. We had Dr. Shri Suresh Prabhu, G7, G20 Indian Sherpa Member of Parliament as our guest of honor for the first and the second edition of Intellectual Property Talent Search Examination. And Shri Anil Sahasrabuddhe, Chairman AICT, as third edition of Intellectual Property Awards and IP Conclave. So here's the list of the college as well as the college and school level winners for the third edition of Intellectual Property Talent Search Examination from schools like Vidyagan, AECS, Mongolia Maruti Public School, and colleges like Gujarat National Law University and School of Law, Christ University. Thank you for viewing the presentation. I hope you all register for the Intellectual Property Talent Search Examination and get the benefits out of it. Thank you.
Thank you, sir. Dr. Sheetal Chopra, your presentation is informative and useful. And it is interesting that you have explained with many real-time examples related to college and university scenario. As many participants we have today are from academic background, hope the presentation will be an eye-opener for them. Thank you, ma'am, for your valuable time and presentation. And again, thank you, sir, Dr. Gupta, sir, for briefing the different exams available for IPR in India. So thank you, sir. Thank you for your briefing about IPR exams. Thank you, sir. Now I request Mr. Robert, Assistant Professor